Welcome to our fifth lecture covering the Module 1 material. And as you can see, we are making good progress on Module 1. We've covered the course introduction, and we've covered the first topic in the the first section of the second topic, in which we talk about the employee status, whether the person is an employee or an independent contractor. For the rest of this lecture, I hope to finish up category number 2 and talk about temporary and leased workers, as well as a few special cases, specifically when students work, situations where there are unpaid internships or people are volunteering their labor, and also the circumstance in which the worker is actually an owner or a partner in the business. And finally, we'll talk about pre-employees or applicants. So that's our goal for this particular lecture. And of course, once we're done with this, then we'll go ahead and another lecture to our third and fourth topic. So let's begin. So what we're going to focus on here is the issue of temporary workers. And I've already touched on this in some of the earlier lectures, so I'm not going to do a tremendously deep dive here. When I talked about it before, I presented a situation wherein a company hires a temporary agency to assist it with staffing. And there's a couple of different ways this can play out. One is that the agency simply screens potential employees, and that once they are screened and selected, then those employees go to work for the company that is actually going to use their labor. Sometimes it's an immediate process, sometimes it's at the 30-day point or the 60-day point or the 90-day point. Sometimes, though, the expectation is that the workers will continue to work for the temporary agency on an indefinite basis. And one of the issues that comes up whenever the temporary agency continues the employment for some period of time is the issue of joint liability. These are very dangerous words. Legal professionals in the employment law area really want to do a lot of work to avoid the possibility of joint liability. Sometimes companies that use these temporary agencies are thinking to themselves, oh, this is a way for us to reduce some of the risks that we're experiencing. We're transferring the risk to this temporary agency. Actually, they probably aren't. They're actually probably increasing their risk, because anything the company that is actually accepting the labor does that violates the law will still be the responsibility of that company that's accepting the labor. In addition, if the temporary agency violates the law, it's also quite possible that the company that is using the labor of these workers will also be liable for the temporary agency's error, even if the other company didn't know about the error and had no involvement in that error. And that's where we get into the idea of joint liability. It is possible to draft an agreement and to have practices that would result in the company that is using the labor of these temporary workers avoiding joint liability when the temporary agency violates the law. It's possible to do it, but it's not at all easy. And one wonders why one would kind of jump through those hoops and accept this risk from another company messing up the employment relationship in this way. So usually temporary agencies, especially if they are a long-term arrangement, are just not a good idea. Hiring folks for a week or two or maybe a month through a temporary agency may make a lot of sense. Maybe even an occasional worker, for example, when another employee is on an extended medical leave or on maternity leave or something like that, can make sense. But using it as your usual staffing process is a way to really maximize the risk that you have from a joint liability perspective. And so it's not a recommended solution. So the definition here for joint liability that I'd probably look to is this one. I guess also including this with respect. So maybe all of this would make a good definition as you prepare your Quizlet. Joint liability is an important issue, and it's an especially important issue when you're looking at using temporary agencies. Another term to keep in mind is contingent workers. Contingency, you're probably familiar with the term, is when something is kind of up in the air. You're not quite sure exactly how it's going to play out. There is some aspect that is uncertain to the situation. And that's what we have with contingent workers. Sometimes it's a temporary employment situation, or it may just be an occasional work situation. Maybe you're called on an as-needed basis. In any event, it's some work relationship that's different than full-time employment. And I would say it's usually even different than long-term part-time employment, especially when the part-time employment is, say, 20 hours a week. If it were less than that, you might call it a contingent working situation. Now, sometimes contingent workers are just employed just like any other worker. They work directly for their employer, the person who is accepting their labor. In that situation, really all the laws that we've been talking about, for the most part, apply to that situation. There are a few exceptions, some very minimal part-timers, people who are really working not a lot of hours, may not be covered by all the laws. For example, the Family and Medical Leave Act requires that somebody works 1,250 hours a year. If you really are only working 20 hours a week or less, you're probably not going to reach that threshold. So there are some times where truly occasional workers may not enjoy the benefits of all of the employment laws that we're going to be talking about. But often, obviously, these contingent workers are actually not employed directly by the company that is using their labor, but one of these staffing or temporary companies may be the actual employer, especially during the early days of the employment relationship. And again, in a situation we face the possibility of joint employment. So the question is, are these folks employees or are they independent contractors? Well, they are employees definitely of the temp agency. But whether they are also employees of the company that's using their labor is a bit more complicated issue. Now, because they are actually employees of the temporary agency, they really aren't independent contractors because they are actually employees of the agency for which they are providing the labor. So they are somebody's employee. Whether they are employed by both entities is kind of an open issue. But I think we can say pretty definitively they're not independent contractors. We've already talked about that concept of joint employer. I mentioned earlier that sometimes we can avoid that possibility of joint employment and joint liability. Again, joint employment and joint liability are pretty much synonyms. So how do we do that? What is the trick to that? And this is how that works. Both of the employers are joint employers and therefore have joint liability if they meet two requirements. They both hire and control the same employee. Control here is the key word. And each business has a relationship with the other business. So it's kind of like a triangle. Here we have the staffing agency. We'll call it the employer in terms of they actually employ the labor, and the worker. And you can see that the worker is directly hired by the staffing agency, but the worker is performing services for the employer. And the employer has hired a temporary agency to manage the relationship with the worker. And so when you have this triangle, you have this relationship. But the reality is that this employer is going to want to control the means in which this employee functions, most likely. The only way that this employer can resist the possibility of a joint liability would be if he really takes a very hands-off approach and leaves it to the temporary agency to really manage that. So, for example, if the employer dictates dress code or dictates when the person needs to be at work, or establishes the training system for that particular worker, has an attendance program that the employer expects the temporary agency to apply. All of those aspects seem very much like control, and it's pretty unusual for the employer to not want that level of control. So it's possible to avoid it, but are you really getting what you want in terms of the labor of that worker if you really aren't able to control it very much? So if you are trying to avoid this joint employment, joint liability scenario, this employer, I mean, definitely this employer is always going to be the employer because the temporary agency is actually paying the worker. So there's no way to avoid an employment characterization in this relationship. There is the possibility of avoiding it here between the employer and the worker. So how are you going to go about doing that? Well, it's really going to turn on two things. Number one, what this contract says and how this company that is using the labor of the worker interacts with the worker. So these two aspects are going to be what it turns on. So you have to be careful about the wording of the contract so that the employer is surrendering all of his rights to manage this worker to the temporary agency. And so you have to draft that language really, really well so that the control aspect is completely in the purview of the temporary agency. But it's not good enough to have a contract that says that. You actually have to follow that. The court isn't going to pay much attention to a contract if the contract says X, but everybody really knows what happens on the ground is Y. So the employer has to actually live those words and continue to follow the letter and the spirit of the contract. So that's a tricky thing to do. It requires a lot of training within the employer organization so that the managers and supervisors know that they aren't managing or supervising the workers for the temporary agency, and that all of their communications are going to have to be to the temporary agency, and they can't be of the type that says, you need to tell Bob he needs to dress more appropriately, or you need to tell Sally she's taking excessively long on breaks. Those types of things, if the employer is simply just using the temporary agency to funnel the management of the worker through the temporary agency, then really the employer hasn't given up his or her authority. Because obviously the temporary agency is going to do whatever the person paying its bills tells it to do. So it adds a level of complication and uncertainty. And the problem is, if you leave it in the temporary agency's area of responsibility to manage the relationship, well, the temporary agency does a bad job, either because it poorly manages the working relationship or possibly it violates the law. Well, if you've been a little bit slack, you may find yourself a joint employer having to defend actions and being liable for actions about which you had no input, no control, and are going to have to suffer the consequences for it. So this is a fairly challenging situation to maintain for a long-term basis. We already talked about a little bit Microsoft's problems, which is kind of called the PermaTemp issue. This was a fairly common approach in the 90s, even also in the 80s. I think most large companies kind of cleaned up their act in the 2000s and since. But smaller companies you may find that they continue to have some of these problems. And what happened was Microsoft and other companies started hiring these temporary workers. They called them temporary, but they went on to work many years. I know of one example of a quote-unquote temporary worker who worked for 15 years, most of that time on a full-time basis. And yet the employer denied her the right to pension to healthcare benefits, even though she was working with regular full-time employees who were enjoying those benefits. A very difficult position to defend. And so I use the example of Microsoft, not to shame Microsoft, but to show you that sometimes very large companies with probably sophisticated legal departments encounter these problems. I'm sure the legal department there was saying, don't do this. But sometimes, honestly, the client doesn't listen to the advice that the legal professionals are giving. So the rule here, to avoid this PermaTemp situation, is that you shouldn't exclude folks from benefits merely because you're calling them temps, if they really aren't temps. If they're doing the same work as your regular employees, and they otherwise meet the definition of regular employees, you can't segregate them by saying, oh, we're putting them into another category, because that characterization becomes arbitrary. Somebody isn't temporary if they've been here for more than 6 months. That's somebody who is an employee at that point. So don't, and again, sometimes clients will see this terminology and say, well, this must have some legal significance. There must be a reason why people call some people temporaries and other people not temporaries. And you sometimes will find unsophisticated clients, and many times these folks think that they're sophisticated, who think calling somebody a temp somehow changes their rights. It's kind of a magic power that the employer has. And so sometimes clients won't bring these to the attention of the legal department. Maybe they don't because they know what they're doing they shouldn't be doing. Or it could be that they are sufficiently unsophisticated that they don't even understand what they're doing is wrong. That it's not on their radar to do this. But that person started out as a true temp, and people just kind of forgot that this person isn't really an employee, or this person has been around for a really long time. That's one of the reasons why audits of employment or departments can be so helpful, because you can discover some of these well-kept and maybe not so well-kept secrets, and help you kind of put a little sunlight into that situation to figure out what you need to do to solve the problem. So we've already kind of talked about the least employee. This is, again, that situation where we talked about this person being a temporary employee, but we're using a third-party business such as a temporary agency that hires that person in some kind of leasing contract. I've seen this happen sometimes with international employees, where folks have been brought in to do a long-term project, and when I say long-term, I mean maybe 6 months, and they have been brought in, and because they're international employees, there's a fair amount of visa paperwork done, and large companies sometimes don't want to be responsible for managing that process. They want to outsource it, and so it becomes easier in some senses to have the temporary agency manage the visas and the recruitment, because of course these workers, because they're from a different country, you have to have your feet on the ground in that country to do the interviews, and to also kind of know what's going on in the industry in that particular country, to be able to identify who's qualified, what credentials would make that person qualified. And so there can be some reasons why it does make sense, but again, you have that joint liability, joint employer concern that can arise under that situation. And of course, you're still going to be responsible for worker safety and employment discrimination laws. And if the temporary or the leasing company violates any of these laws, the employer using the labor of these individuals, that company is also going to be at risk. Let's look at a couple of scenarios to see how this might play out. So we have this company that is employing some part-time workers through a staffing firm. Now, one of the managers at the company, at Empire Penguin, asked the staffing company to replace one of the workers with someone of a different race. Guess what? A lot of staffing companies would be willing to do this. I'm not defending it, but I'm just telling you realistically, staffing companies recognize that they are just really the messenger in many cases. And so this manager is thinking he can get away with this or she can get away with this by having somebody else do the dirty work for him or her. But the reality is that while the staffing company is going to be liable, also Emperor Penguin is going to be liable. The employer will be liable as a third-party interferer under Title VII. So you're not going to be able to avoid liability simply because you are not the statutory employer of those particular workers. So we have a supermarket. It hires a temporary salesperson through a staffing firm. And again, the salesperson is not paid directly by the supermarket, but by the staffing firm. Obviously, the supermarket is paying the staffing firm, and the staffing firm is paying the salesperson. After 3 months, the manager of the supermarket says, I don't like that person. He keeps on missing work because of his religion. Give us someone of a different religion. Again, some staffing companies will be willing to make that change. And so the staff person is removed. And under that situation, both the staffing company and the supermarket are going to be liable under Title VII. So we've completed the analysis of temporary and leased workers. Now we're going to talk about several special cases. So let's begin talking about that scenario. We're going to look at specifically at student employees, interns, by this I mean unpaid interns, volunteers, and the situation where you have a partner. So this is an area of the law that is evolving, especially with respect to the NLRA, the National Labor Relations Act. I'm going to not test you on the union organizational aspects of this. The reason I'm not is because this area of the law is evolving pretty significantly. Right now it appears that teaching assistants and other students who also work for their university can organize in unions. The issue, or what I guess makes this question interesting from a legal perspective, is that these students are really wearing two hats. They are students, and because they are students, they are receiving this opportunity to work. And the idea is, well, the university wants to facilitate them working so that they can continue to be students because they have bills to pay. Also, the employment that they have is designed in many cases to advance and augment their learning experience. So for example, if I'm a graduate student and I'm having a job as a teaching assistant, I am developing skills that are probably going to be very helpful for me as I advance in my academic career, because very likely I'm going to become an instructor at some point in my career once I complete my education. So there is the idea that I am learning as part of the tasks that I'm performing. We also see on the undergraduate level work-study arrangements where students are in college attending classes, but they're also receiving some work-study type of stipend. They're able to work a certain number of hours, and they do this through the college experience. Again, they only have the opportunity to do this because they are students at the school. And so the issue is, well, are they primarily students or are they primarily employees? And the NLRB, the agency that administers the NLRA, has come down on both sides of this issue. And honestly, the NLRB will talk about it in more detail later on, but it tends to be one of the more politicized agencies that we'll be talking about. And so typically, or I guess this is always true, if we have a Republican president, the board, the National Labor Relations Board, actually has 5 members, then 3 of the members will be Democrats and 2 of the members will be Republicans. When we have, that's when we have a Democrat as president. When we have a Republican as president, we have 3 Republicans on the board and 2 Democrats. Well, since it's a majority rule situation, as you can imagine, usually the votes are going to be 3-2. So if there's a Democrat in the White House, then you're going to see that the NLRB leans much more Democratic or much more liberal, much more pro-union. And when you have a Republican in the White House, and you'll see the NLRB focus much more on conservative or perspectives that are more pro-employer. So you'll see a variety of approaches in this area, but certainly the trend has been in recent years, even though while President Trump has been president, the NLRB has continued to allow there to be unionization within colleges. And obviously, they've always allowed the instructors to unionize, but to allow students to unionize as long as those students are also employees. And there may even perhaps be the possibility of football players for schools being able to unionize. So this is, again, an evolving area of the law. I don't consider it settled for sure, so I'm not going to be testing you on it, but I wanted to flag this as an issue. So as you progress in your career, you can kind of keep this in the back of your mind. When you see new cases on this point, you'll kind of know the context for this. But generally, outside of the labor area, student workers, and whether they be TAs or work-study workers, are going to enjoy all of the legal protections that we've talked about in the other statutes. So really, the NLRA is one of the few laws where you might see some rights not being in play for the student workers. But in the vast majority of cases, a student employee is going to have the same rights as somebody who isn't a student in that particular organization. The issue of internship is one that has changed since I was in college. Internships weren't nearly as common. And when I say internships, I mean unpaid internships. And in reality, they've become more common, but it's a pretty, this is my opinion, so maybe you don't share it, but it's a fairly unfair situation because most students can't afford to take unpaid internships. So what happens is individuals who have more affluent families who can afford to take the unpaid internship find that unpaid internship they take leads to full-time employment. But the person who can't afford to take an unpaid internship because they have bills to pay can't initially take up that unpaid internship, so they never are considered for the job. So the unpaid internship is kind of a tryout basis for the paid position. That's sometimes how these types of internships play out. And it's quite unfortunate. And it's actually, in most cases, violating the Fair Labor Standards Act because, again, workers are entitled to at least minimum wage for the hours they spend at their employment. Now, some internships are situations in which the intern is not performing services that actually benefit the organization. For example, if I'm job shadowing somebody, or I am simply being present in meetings, and I'm not really adding anything to that meeting, then it's appropriate that I'm not paid for that because I'm not helping the organization. But if I am doing some things that add value, maybe taking notes of the meeting, maybe doing some administrative tasks in the office, then under those circumstances, I ought to be paid. It would be a violation of the Fair Labor Standards Act for me not to be paid. So I wanted to flag this as an issue. This is an area where large companies and small companies alike oftentimes are not in compliance in this area. So in most cases, internships should be paid. They certainly can be paid at a relatively modest level, but they do need to be paid at least at minimum wage in order to comply with the Fair Labor Standards Act. And the agency that administers the Fair Labor Standards Act is part of the U.S. Department of Labor. It's the section that's called the Wage and Hour Division of the Department of Labor. We'll talk about lots of agencies as we go forward, but the Wage and Hour Administration is a more aggressive agency than some of the other ones that we'll be talking about. And so usually when employers get a call from the Wage and Hour Administration, their ears are pricked up and they want to make sure that they are solving the problem so that they don't have some bad implications or bad results from their interaction with a government agency. This government agency can be on the aggressive side. Let's talk about volunteers. When I worked at JCPenney, we had a program most years in which, as I worked in the office here in Plano, and we had a program in which employees who work in that office were able to help out during the Christmas season in the stores. And in fact, I did that most years that I was there. I was responsible for a gift wrap station. Others might have been involved in package pickup or running a cash register or other tasks. I wasn't, by the way, very good at gift wrapping. I gave away a lot of free gift wrapping, to be honest with you. But it was a way to help staff those stores. And so we were volunteers in some sense. We didn't have to do it. And we would go to the stores and kind of be trained to do it. The hourly paid employees, though, the ones who perhaps were administrative folks, maybe receptionists, secretaries, other folks that were compensated on an hourly basis, when they would volunteer and then they would go to the store and help maybe the gift wrap station, they would be paid for their time in the gift wrap station. So let's imagine they work 8 hours during the day and then they spend a 2-hour shift in that evening. And let's say they earned $20 an hour during their normal work day. Well, then they would earn $20 an hour for each one of those additional 2 hours that they worked. And of course, if they went over 40 hours of work, whether it was the volunteer or the normal job responsibilities or some combination, then they would become eligible for time and a half at that point. So we called them volunteers, but they really weren't volunteers in the sense that they weren't being compensated for their time. They were being compensated for their time. They just were not required to do these particular tasks. Now you may think, well, you mentioned how that worked for hourly paid folks, but how did it work for you? Because obviously I was an attorney, so I wasn't paid on an hourly basis. And so when I volunteered, I wasn't compensated additionally for that time. In some cases, at JCPenney, sometimes managers would leave work a little bit early. And so maybe some of their normal work schedule was replaced by this volunteer work. But most of the time, I think most of us just worked a few extra hours that week. And because we were salaried individuals, and we'll talk more about what that means in a little bit, but because we weren't compensated on an hourly basis, we didn't earn any more money for that particular week than we otherwise would. So in that sense, I guess we were perhaps true volunteers. But usually when we talk about volunteers, we're talking about people who are hourly paid. So the first thing to keep in mind is you can't volunteer for an employer for whom you are already receiving wages. And that would be the case even if you go to work for a charitable entity. If I go to work, say, for United Way, and I am a receptionist, and United Way says, hey, we need some extra help at the Boys and Girls Club. Would you mind volunteering for that? I said, I'd be delighted to volunteer. I love that organization. Well, guess what? I'm going to have to be compensated for that time because I'm assuming that Boys and Girls Club is a United Way agency in which there's United Way staff there, and I'm not sure all the technicalities. So let's imagine it's set up that way. You can't volunteer for your current employer. You also usually can't volunteer for a for-profit entity. Now, obviously, you can volunteer for charities. I can volunteer, because I don't work for United Way, I can volunteer the Boys and Girls Club. And Boys and Girls Club doesn't have to compensate me at all. But let's say that there is a daycare that is for profit. I can't say, you know what, I would just love to spend some quality time in that daycare center. And I don't need to be paid, and so I just like to arrange to be able to drop in every Thursday afternoon and, you know, cuddle with some babies or play on the playground with some toddlers or something like that. That would be fun for me. Well, if it's a for-profit entity, very likely I'm going to need to be compensated because, again, presumably I'm doing something of value for that entity. Because I'm out on the playground watching the little ones, that means that another staff member can maybe take a break or watch some other children. Or at a minimum, there's more adults watching the children than there otherwise would be. So the children are better cared for. So usually it's difficult to have volunteer status for a for-profit entity. It's possible to imagine that. For example, we do see volunteers in our public schools. The public schools, of course, are not a for-profit entity. But I would argue that if you see a private school, and of course most private schools aren't for-profit entities either, but you could imagine a private school wherein it is a for-profit entity, but the parents get involved in fundraisers and bake sales and maybe doing other tasks in the school. I think you could make an argument that those people could volunteer in that context. So I wouldn't say that it's impossible to have a volunteer, somebody who's doing work who isn't being compensated, even though the employer is for profit. But you would need to have an understanding as to the motivation for that volunteer. If the volunteer is there in the hopes that because I'm volunteering, it's going to lead to me getting a normal paid job, if that's my motivation, then we have the same problem that we would have with the internship situation that we talked about before, and that's just not going to fly. Let's talk about partners, and this is an issue that is especially relevant to legal professionals because a large portion of law firms are organized as a partnership. And if you're talking about a large law firm especially, you may have 100 or more partners. When you have an organization that big and when you have such a diffuse ownership situation, there's a pretty good argument that some of those quote-unquote partners really are less like owners of the business and more like employees. That's especially true when you are at a lower ranking level. You may own a very, very small part of the enterprise. And depending upon how the partnership agreement is structured, you may not have a lot of say-so in how the business is run, and you may actually be able to be removed from your partnership position. So we've seen a few cases where partners in law firms have sued. Oftentimes it's because of the claims of age discrimination. Many partnerships historically have had a mandatory retirement age for the partners. They can't have that for the employees, but because the partners were owners as opposed to employees, many law firms had these dates where the partners had to leave. And so law firm partner says, I don't want to retire. I don't want to retire at 65. I don't want to retire at 70. And then they have sued alleging age discrimination. The EOC has sometimes permitted these partners to advance the claim, arguing that, because they haven't permitted the partners would be able to sue, even the EOC disagreed, but they have supported, we'll put it that way, the partners' claims under the Age Discrimination and Employment Act. And again, the facts need to be pretty persuasive. You would really need to see facts along this line that really undercut the argument that these quote-unquote partners aren't really partners. So if the partners really don't have influence in the workings of the firm, if they can't vote on partnership issues, if they don't receive a division of profits, those would be indications that while they might technically have a named partner, the substance of the arrangement perhaps isn't a true partnership situation. So these are factors that the EOC says are important to consider. I'm not going to go through them, but you can see these are the things that could put into jeopardy the finding that the partner is not an employee. You know, conceptually, somebody who's a partner, by definition, can't be an employee because you're the owner. You would be therefore employing yourself in some sense. But in larger firms, or even in smaller firms, where you might have one or two major partners, in fact, there are law firms out there where you might have 5 people who are called partners, but 1 or 2 of the partners owns 70% of the profits of that entity, and gets to vote 70% of the votes. And so you can see there that the other partners have a very negligible or small influence upon the organization. And so it really requires a more complete picture than knowing whether the person goes by the term partner or not. So let's talk about the situation of undocumented workers. When I use the term undocumented workers, I'm talking about individuals who don't have the correct paperwork to be eligible to work in the United States, and yet they are still employed in the United States in some kind of capacity. So this situation obviously means that those individuals can be in a very vulnerable position. The employer can threaten to out them in terms of their immigration status to the government, and obviously if the employer does that, those undocumented individuals might be deported as a result. And so it's difficult for an undocumented worker to complain about working conditions, pay, safety issues, discriminatory practices in that circumstance. The law is not very well defined in this area. It really turns kind of statute by statute about whether the undocumented worker can advance claims of things like back pay or discrimination claims, even though he or she is not legally eligible to work. As we go through each one of the statutes, we'll address the issue about what the courts have said about that particular statute's relationship to undocumented workers. And so I won't go into more detail about that now, but just know that it's kind of a statute by statute approach on this particular issue. And later in the course, we'll also discuss the various types of authorization that are necessary to work. And we'll also talk briefly about how visas work, H-1B visas, other visas, F-1 visas, how they play a role in the employment circumstance. So now we have covered 3 of our 4 topics under our second topic, which is the worker as an employee or other. And our final category is going to be the topic of applicants. These are kind of pre-employees, at least they hope to become an employee. And so this discussion is about whether a person is an applicant yet, or what does a person have to do to get that kind of legal, that legal term applied to them. And here we have the definition here. So again, if you're working on Quizlet, you may want to use this definition to prepare for. So some statutes don't apply to applicants at all. The National Labor Relations Act, in most cases, doesn't apply to applicants, although there's one exception which we'll talk about as we get farther into that. But the discrimination statutes do apply to applicants, and it wouldn't make sense for them not to. Can you imagine a law that says, well, an applicant, you can discriminate against an applicant based upon his religion or race or national origin or gender, but you can't once you hire them. Well, you can see a discriminatory employer in that situation. We just never hire a person in a category that he intends to discriminate against. And so you have to provide that protection for applicants, or the whole system doesn't really work from a discrimination perspective. As we go through the statutes, we'll talk about in each case whether applicants are covered. But in most cases, we'll see that applicants are covered if it makes sense. Obviously, an applicant isn't entitled to wages, so you don't have the Fair Labor Standards Act applying to applicants. But let's talk about what actions that person who is applying for the job has to take to kind of cross that threshold and become an applicant. For example, imagine that I am looking at a job board and I see a job that looks kind of interesting to me. And I think to myself, I think I'll apply for that job later on this evening after dinner when I have a little bit of time to work on that. I'm clearly not an applicant yet. The potential employer doesn't even know I exist at this time. So I'm going to have to do something that alerts that potential employer that I exist and that I'm interested. But it's actually a more demanding requirement than I simply alert them to the fact that I have some level of interest. The applicant threshold is a little bit higher than you might think it's going to be. So let's look at what I have to do to become an applicant. The person must submit some type of expression of interest, and in that expression, the person has to indicate that the person possesses the qualifications for the posted job. So if I just call up and say, I'm interested in the job, and that's all I say, that's not enough. I'm going to have to say, I'm interested in the job, and I see that you want somebody who has graduated from high school, has 2 years of work experience, and can type 40 words a minute. I have all three of those requirements satisfied. That would mean that I've satisfied this first element here. Let's look at the next one. The employer has to actually consider the person for employment. Maybe the employer has already filled that job or has decided against filling the job. Or maybe the application doesn't get routed to that right department. It gets lost in the shuffle. And so nobody actually ever connects me, the applicant, with that opening. Or maybe I apply for one position and nobody forwards my application for another similar position. So I wasn't considered for that other position. So this would be the second requirement. And then finally, I have to, in order to maintain my status as an applicant, I can't remove myself from consideration. As soon as I do that, then obviously that potential employer is entitled to say, okay, we're done with you because you're done with us. So if I become disengaged from it, I'm not responding to emails, I'm not responding to telephone calls, or I said something that indicates maybe I found another position, or I want to stay where I am. If I do something along those lines, then I may have been initially an applicant, but I cease to be an applicant when I took one of those steps. So let's consider a scenario here to see how this can kind of play out. So we have Mary. She just graduated from college. She has her degree, and she sends an email to a company. And she's attached her resume to the company. So it certainly seems like she's aspiring to be an applicant. However, in her email, she only mentions about an interest in a particular position, an entry-level position in the organization. So she's done the first element, she's expressed her interest, and she's, we'll assume that she has shown how she's qualified for this entry-level position. But she's only put herself as an applicant for that one particular position, the entry-level position. She hasn't made herself an applicant for more positions. So after she applies through her email, she finds out that the company has hired two of her classmates who happen to have a different ethnicity than Mary does. So Mary files a claim of discrimination. She's wondering, why did Bob and Susan get the job and I didn't? It must be because of my racial background. And unfortunately, her email inquiry wasn't enough to qualify as a job, unless, of course, this entry-level position that she's talking about is the one that the two classmates were hired into. But maybe they were hired into a different entry-level position. Well, it's not the responsibility of the potential employer to look at Mary's resume and say, well, well, she's not a good fit for this job, but maybe somewhere in our organization we have another job. No, they aren't responsible for matchmaking her into a different position. It's Mary's job to do the legwork and to say, oh, I'm also interested in doing this, I'm also interested in doing this. Now, of course, there would be no violation of law if the potential employer did forward Mary's resume to other departments saying, hey, she's not a good fit for us, but maybe she's a good fit for them. It's just that that potential employer isn't required to do so. So at this point, we have completed our first PowerPoint. We've covered all of our topics. In part 2 of Module 1, we will cover our second 2 topics. So if you have any questions, of course, feel free to stop by my office hours. I would be delighted to talk to you in more detail about this. I thank you for your attention, and I hope you have a wonderful day. Take care.